And the first thing on our agenda is that we have a speaker that's going to be speaking on the criminalization of immigrants. And I'm going to turn that right over to Sarah to introduce our speaker.
Thank you. Thank you, Judy. Leslie has a long history of, well, she's not that old, a long history of volunteering with immigrants in the immigrant area. She did social justice work. She's been involved in the anti-war and feminist organizing in the 1970s. In the 1980s, she began working and volunteering for immigration justice, helping asylum seekers from El Salvador and Guatemala with their Southside Presbyterian Church. She currently volunteers with Save Asylum Coalition, the Tucson Rapid Response Network, Southern Borders Community Coalition, and of course she really organized the Streamline coalition while it was in operation. So we're just delighted to hear her. Nobody else in this area has so much more information about criminal justice than Leslie. Go ahead, Leslie.
Thank you for that introduction. And just, it's not so much that I know a lot about criminal justice, but the Streamline Coalition has, we've learned a lot about the criminal prosecution of migrants and asylum seekers. So that's our area of focus. And do I have permission to share my screen? Because I'm going to show you a short PowerPoint.
Yes.
Did you already set that up? It's set up, I guess.
Okay. So here we are. And can all of you see that?
Yeah.
Okay. And okay, so here we go. This is I have a longer version of this that when we have visiting groups that are on border study tours, but I'm gonna do it quick.
She's got to show her.
Can you all see this?
Yes.
Okay.
Okay.
So
Les says excuse me, Leslie. Les says that you have the wrong screen, and I don't know what he means by that. So he's going to have to.
Are you running PowerPoint?
Yeah, and you should see a screen that has a title that says.
What you're showing us is your development screen, not the PowerPoint screen. You got to change to the other screen.
Okay.
Just go to share screen and pick the other one.
Okay. Let's stop sharing, and I'll try it again. On my screen, it looked like I was sharing the right thing. So, what do you see now?
It's the same one.
Okay, but then I should be in the presentation
Will this
mode.
one work?
Now I should be in presentation mode here.
Perhaps that might work.
Do you see a title that says criminalization of migrants?
Well, we do, but we see it in PowerPoint, not in presentation.
Oh, huh. That's very well. Let's just move on because what I see on my screen.
Yeah, you can run it in that. That's fine.
Yeah. Okay. Because I don't want to troubleshoot while you're on limited time this morning, if that's okay with you.
Sure.
Okay. So we're going to go through this quickly. And I know that some of you already know this, but in case others don't. So when we talk about the criminalization of migrants, we're talking about a couple of laws that are used to do this. And as you see on the screen on the lower part of the slide, the laws are Part 8 of the US Code, Section 1325. This is a criminal misdemeanor, punishable by 1 to 6 months in prison. The other is Part 8 of the US Code, Section 1326, illegal re-entry. This is a criminal felony, punishable by.
You're gonna have to go to your PowerPoint, not the presentation, and move down that way, as if you were working on the slides. There you go. That's what you got to use.
Okay, we made it. Okay, good. There it is.
Now you're on the right slide. Well, thanks for
Yes.
telling me. Thanks for telling me, you guys. So 1325, illegal entry, criminal misdemeanor. US 8 US Code 1326, illegal reentry, that's a criminal felony. So what happens is when migrants attempt to cross the border without authorization, they are captured, not always, but often they're captured by the Border Patrol, and some of them are selected to be referred for prosecution as a criminal. And these are the laws that are used for that. So the Border Patrol, before the pandemic, the Border Patrol would bring them into Tucson, process them, and refer some of them into the criminal system for prosecution as though they were criminals. And they do this in collaboration with the U.S. Attorney's Office, because the U.S. Attorney is who has responsibility for determining who is going to be charged with federal criminal laws. So these are the laws, as you see on this slide. And so a quick, this next slide is designed to get across the idea that when we have different federal agencies with roles in immigration, the Department of Homeland Security, of course, and within the DHS, we have Customs and Border Protection that includes the Border Patrol and also the officers at the ports of entry. The Department of Justice is a whole separate federal agency. And there's a couple of other federal agencies that have to do with immigration. But when migrants are referred for criminal prosecution, they're referred from one system into another, into the criminal system. So also among the migrants who might get referred for criminal prosecution, among those captured by the Border Patrol, some are asylum seekers. And the Border Patrol is supposed to ask people, but they don't always. And some migrants volunteer the information, but some are too frightened to do so, or the whole thing's happening so fast. So some asylum seekers are swept up into this and can be referred for criminal prosecutions. This is not done to children or families crossing with children, but they will sometimes refer single adults. Sometimes they separate single adults from family members that they're traveling with, and then they'll prosecute the adults. So this means that these asylum seekers are routed into this federal system to be prosecuted as though they're criminals. And in the criminal system, they do have a right to be assigned to a lawyer. So they will get a defense attorney appointed who will help them, but they can't get help with their asylum case from this defense attorney who's assigned to them, because they're not in the asylum system. They're in a criminal court. They're going to be in a criminal court, and they're in the criminal system, and it's a criminal charge. And that's what the lawyer is there to do, and that's the kind of law they know about. So just a quick note about the laws that we're talking about. Migration has not always been a crime, or regarded as a crime, I should say. Maybe we shouldn't even say it's a crime. It hasn't been regarded as a crime in our domestic law. 93 years ago, 94 years ago, it was not a crime. But in 1929, Congress was persuaded to pass a law called the Undesirable Aliens Act of 1929. And it was totally motivated by racism, aimed at Mexicans who were crossing back and forth into the United States to work in farm labor. The law, when Congress debated this law, it was strongly championed by Senator Coleman Livingston Blease, whose picture you see here, who is a self-avowed white supremacist. He used that term proudly to describe himself. And also by this guy who was the Secretary of Labor, a proponent of eugenics, eugenics was sort of a popular notion at that time. So the law was passed in 1929, and it was later incorporated into the U.S. Code in the Immigration and Nationality Act of 1952. So that's the roots of these laws. And even the racist intent of the law is there's so much documentation of this that it was actually recognized in a legal decision in Nevada just this past August. A migrant was charged in Nevada with illegal re-entry, the felony charge, and decided to fight his case. And he and his federal public defender argued that he should not be convicted because the law was motivated by racial animus. And so the judge agreed with that after listening to all the evidence that was presented, and he won his case. Probably what happened, even though he wasn't convicted as a criminal, he was probably after that deported. And this was just one case, so it didn't strike the law from the book, but it shows us how much evidence there is of the racial roots of the laws that we're talking about this morning. So we had, as you know, we have this group called the End Streamline Coalition. So we didn't have these streamlined courts until the 2005. So the CBP, so before I start talking about this, the laws were adopted in 1929 and incorporated further into our law in 1952, or whatever I said, 51. But we used them on and off. They would be used to prosecute migrants when there was a lot of anti-migrant feeling and didn't want people to come here. But sometimes we didn't feel that way. For example, during World War II, we needed more migrant labor, so then they wouldn't use the law. So the law would be used or not used depending on attitudes toward migrant labor. And so there was a growing anti-migrant fervor that began in the late 90s into the 2000s, grew even more after 9/11, as you all probably know. And then they decided to ramp up the use of these laws. And in 2005, CBP adopted a policy called the consequence delivery system. And they really wanted this was one of the consequences. They were going to prosecute a lot more people as criminals, thinking that it would have a deterrent effect. And so to achieve the volume that they wanted to prosecute people, they invented mass prosecution courts and named them Operation Streamline. The first of these new kind of courts was implemented in Texas in 2005, and then they began implementing them all along the border, and Tucson got it in 2008. And Tucson was one of the largest of these mass courts, these mass Operation Streamline courts. So the result of this was a massive increase in criminal prosecution and incarceration of migrants. And we're basically, so it's like a giant factory transforming migrants into criminals. Contributes to mass incarceration of Black and brown people in the US. Everything happens so fast that there's lots of opportunity to deny due process. Criminal convictions can mean that there's no future way for a migrant or an asylum seeker to enter the US. Asylum seekers can be denied any access to asylum if they have this kind of conviction. Feeds the growth of the private prison industry hugely. And there's enormous taxpayer costs that no one really knows what it costs to do all of this. Just a quick graph. This is from 1986 to 2015. And I like this graph, even though it stops at 2015, because over on the left, you can see that there were very tiny numbers of people being prosecuted for illegal re-entry in the late 1980s. It's just an illustration of the non-use of the existing law. And then you can see the little arrow at the bottom, if you can see it, shows when Operation Streamline was introduced and how the huge increase in prosecution for illegal reentry that took place after that. So what's happening now? Streamline was stopped. I think the word halted is a good word. Streamline was halted in Tucson and probably all over the border in March of 2020 for two reasons. One, the court didn't want to have a whole bunch of people jammed into a courtroom in a mass prosecution because of the danger of COVID. But the other reason was we had the Title 42 border closure. And so instead of bringing people into Tucson or into a town like Tucson to process them, and where some of them could be referred for prosecution, they were quickly expelling people right at the border, out right in the field. The field agents would just be expelling people. So there were fewer people to be selected for prosecution. And they also just didn't want to be holding people in places like Border Patrol stations or places like that because of COVID. So this graph is a graph that's a kind of a little dramatic little graph of first-time border crossers charged with illegal entry. Before the pandemic in January and February of 2020, in Tucson, in the Tucson court, we were prosecuting between 700 and 800 a month for first-time border crossers. That was kind of the norm because we had Streamline. But then when they stopped Streamline, we have now 0 people being prosecuted as first-time border crossers for illegal entry. That's the misdemeanor. And that continues to be true. But there are people being prosecuted for illegal re-entry. So before the pandemic hit, we were prosecuting between 1,000 and 1,200 people a month for illegal re-entry. And then that dropped to very few, when Streamline was stopped in the first month or two of the pandemic. But then they began increasingly to prosecute illegal people for illegal re-entry using a regular prosecution method, like the regular way people are normally prosecuted, as opposed to the Streamline way. So you can see from this slide, illegal re-entry prosecutions dropped by about 80%. So we're still prosecuting approximately 200, 230 people a month in Arizona using a regular prosecution method. And the way that works is a defendant who's going to be prosecuted in this way is held in a private prison, in a detention center, although they're held in the U.S. Marshal's custody for about 4 or 5 months. That's how long it takes it to play out. There's a series of hearings. They appear by video teleconference or even sometimes by phone. The hearings are initial appearance, detention / preliminary hearing, change of plea hearing, and finally a sentencing hearing. The defense attorney might, in the first year or so of the pandemic, they typically could not meet with them in person because of the pandemic. I think more often now they can. But sometimes it would just be talking to their lawyer on the phone. And as I said, it takes several months. Some defendants prosecuted for illegal re-entry might have past convictions on their record because they've lived in the United States in the past. So they might have some past illegal re-entry convictions. This might be the 4th time that they've been charged with illegal re-entry. Or they might have in the past gotten a DUI or something, been convicted of a DUI or something else in the past. If so, they will be recommended for more time. So if they don't have any other past convictions, the maximum sentence they can receive for illegal re-entry is 2 years, and they might get less than that. But if they have other past convictions, more time might be added to their sentence, including if there's some categories of past convictions in the state where this conviction might have occurred, whether it's Arizona or California or someplace. And these charges can be collectively identified as aggravated felonies, even if they weren't actually felonies, because there's in the domestic law, in our domestic immigration law, I think it's the IRA law, but I'm not sure. There is a place in the immigration law where there's a denotation of a collection of offenses that are given the label aggravated felony. Some of them are felonies, but some of them aren't even felonies, but they're labeled as that. So if a migrant ever has a conviction for one of these kinds of offenses, it can be tacked on to their illegal re-entry charges as an aggravated felony. It's not really, whether or not it's a felony, it's kind of a confusing thing to explain, but this will cause them to even get more time. Even though they may have already been convicted, paid fines or served prison time and so-called and quote unquote paid the price for these past convictions, they will be piled on to their illegal re-entry immigration charges. If they get a sentence, and after they serve their sentence in a criminal facility, then after that's completed, they'll be transferred back to ICE custody and probably be deported. If they want to try to fight their deportation, they will need to. That's now, you know, they've been in the criminal system. Once they're transferred back to ICE, if they want to fight their deportation, they're back in the immigration system, and they would be best off trying to get a lawyer, if they ever could, to help them fight their deportation. So, last thing to talk about is a question that's been on a lot of people's minds: will Streamline come back? Because it's been now 2 years that it's been halted, but it hasn't been ended on a policy level. It's just been halted because of the circumstances of the pandemic. So we have been, this whole 2 years, and Streamline group, we normally monitor Streamline hearings. We try to have people in court every day to monitor the Streamline hearings. The Streamline hearings haven't been held, but we've been monitoring the court calendar to continue to track what's going on. So in the past 6 months, we started noticing that they've been having some hearings that they hadn't had before that are listed on the court calendar in Tucson, but also in other parts of Arizona as plea and sentencing hearings. And so these are hearings where a migrant is going to be charged with illegal entry, but they actually have two charges. Charge one is illegal reentry, and charge two is the illegal entry. So they're charged with both the misdemeanor and the felony. And this is similar to the approach that was used when we had Operation Streamline. The people who were in Streamline, who were charged with the felony offense, illegal reentry, would actually have two charges. They would have the misdemeanor charge and the felony charge. And so they would be offered a plea bargain. This was in Tucson, but now in these plea and sentencing hearings. The plea bargain, so in the plea and sentencing hearings that we're seeing now, the plea bargains and the resulting sentences are handled all in one hearing instead of being in two hearings. Also, we're seeing multiple people scheduled at the same time. So this week, just the week that we're in now, on Monday, there were 19 people scheduled all at 11 o'clock in the morning in Yuma. And on Tuesday, there were 15 people scheduled at 3 o'clock in the afternoon in Tucson. There's sometimes also people just scheduled individually on the calendar for plea and sentencing hearings. But these are similar to what we used to see in the Streamline sessions in Tucson, where when somebody had these two charges, they would be given the opportunity for a plea bargain where if they agree to plead guilty to the illegal entry, the lesser misdemeanor offense, then the government would agree to drop the illegal re-entry felony offense. And then the defendant would just be convicted for the illegal entry. And again, the penalties for that is between 1 and 6 months. So we're seeing, and I'll show you a little graph. We were seeing, just a few of these each month, like maybe 15, 20, 25 a month. I'm sorry, a week, 15, 20, 25 a week across the state. Most of them were in Tucson, but sometimes they would be in Yuma or Phoenix. And then in recent weeks, in the last 5 weeks or so, we're seeing a trend upward of more of these plea and sentencing hearings. Last week, there were 69 plea and sentencing hearings in 1 week. This week, there were not as many, about 48. So we're watching that. In the plea and sentencing hearings, just as I explained for the people that are prosecuted one at a time, they appear by video teleconference, but they appear in groups. So there might be several of them on a Zoom screen. But next week, we understand that they are going to start having these plea and sentencing hearings in person. Katrina Schumacher went to Yuma. She actually drove all the way to Yuma last Monday to observe the 19 people that were being held, that were being in these plea and sentencing hearings there. And she heard in Yuma, they're going to start doing them in person. And then I observed the ones in Tucson on Tuesday, same thing. So we're going to watch this next week. We think that most of these people that are being prosecuted for illegal re-entry, the one-by-one people that are being prosecuted in a regular manner, are recent border crossers. And same thing with these plea and sentencing hearings. The people with the regular prosecutions, by recent, I mean they might have crossed the border last summer or last September, and they've been sitting in prison while the prosecution plays out. The plea and sentencing hearing people were probably captured. Most of them seem to have been captured by the Border Patrol maybe 2 or 3 weeks, or even just 1 week before they appeared in their plea and sentencing hearing. So that's the trend that we are seeing at this time. And I am going to stop sharing and see if you have questions. Go ahead, Sarah.
Okay. How does the Border Patrol decide who should come to court and be criminally prosecuted?
We don't know. We have tried to find out over the years, even when we had the Streamline court in session. We understand that they do have a set of criteria, and a Border Patrol agent will collaborate with a representative from the Arizona U.S. Attorney's Office to make decisions about who is selected for prosecution. So the short answer is we don't know. We know that they don't prosecute a parent traveling with a child. We think they don't prosecute people that are very disabled or very old or very pregnant, although we certainly have seen in court people that appear to be very injured. So the short answer is we don't know, but we know that they are supposed to have a set of criteria, but we haven't been able to find those. We haven't been able to find a public record that has those criteria. John?
I'm sorry I'm late. I was on another conference call. When these migrants are brought in, which detention centers are they coming in from? Because I've been up at documenting quite a bit at Eloy and that area. where are they coming from?
My understanding is that the ones that come through the Tucson sector and come through the Tucson Border Patrol station are held in Florence. When Katrina was in Yuma, she saw that the Yuma people were being held in the La Salle Detention Center, which is it near San Luis, Katrina?
Yeah, it's right in San Luis.
Okay, because I've been documenting a lot of buses coming in out of Eloy
I
and in
get the
Florence.
screen that shows everyone, so I can see who all is here at once.
Judy, mute yourself.
I'm sorry, pardon me.
Yeah, you being there is a big help, John, but that's our understanding. But also, we'll see. We just keep monitoring as best we can to understand how this is working.
Thank you.
This is Anna Marie, and
Yeah.
the thing that's coming clear to me is why people can talk about the criminals at the border. We have set up the system so that we can call them criminals. And so when politicians are saying about all the criminals at the border, I can see now how they say that.
Mhm.
It's not a happy thing.
It's a good point, Anna Marie, because when we see statistics published in journalism or by the government or politicians' statements, it's good to see if you can read any fine print about. Sometimes there is fine print where they will say non-immigration related criminal convictions or something. Because these immigration criminal convictions get combined. There are some migrants who do have past criminal records, but usually they're for kind of garden variety things that all kinds of people living in the United States who aren't immigrants get charged with. So it's, but they also the statistics will include people whose criminal conviction was for 1325 or 1326. And they really aren't a criminal. We treat them as though they're criminals. Sarah.
Yeah, Leslie, could you clarify that anybody coming in asking for asylum is coming in legally? Their process of coming in is legal.
Yes, and this is if you read the law about asylum, which was in the 1980 Refugee Act, it spells out what the criteria are, like a person with a well-founded fear of persecution based on race, national origin, and so on, and that such a person may present at a port of entry. The law also says they may enter the United States for this purpose, quote unquote, between ports of entry. Now, I don't think anybody has ever litigated this, but because we've wondered this for a long time in Streamline Coalition, that the Border Patrol regards people who cross outside a port of entry or tries to do something, fraudulent going through a port of entry. They regard them as an illegal border crosser. And so they will apprehend them and treat them as an illegal border crosser, even if the person says, wait, I'm here for asylum, I've been threatened and tortured and so on. The Border Patrol agent, if they're doing their job right, hopefully will note that on the paperwork. They will still take them into custody, and that person might still find themselves in a bunch of people referred for criminal prosecution. They're supposed to be taken aside and put into an immigration, sent to ICE for a screening interview called a credible fear interview, or if they've crossed before, it's called a reasonable fear interview. But especially during Streamline, everything happens so fast. They just get sent into the criminal system, and so we don't have time to talk about how it's supposed to work and how it works. But remember that slide I showed about them being sent from one system into another? Once they're sent into the criminal system, they're in that system, and every time they try to raise their asylum claim, if they aren't too scared to do so, they are told, we can't help you with that here. You're going to have to bring that up with ICE. They have to somehow understand when they're back in the immigration system in the custody of ICE. That's when they can bring it up, and then somehow the system is supposed to work right at that time for them to get the process that they deserve to get, which is credible fear interview. And if they pass that, so it's a short answer to your question, but it's a cloudy issue.
Sometimes it depends on the attorney. There's some criminal attorneys who are very, very careful about helping their client make a connection with immigration so they can be set up to ask for asylum the minute that's possible. And some attorneys, they're not interested because it's not their job. When I was in Yuma last week, there were 19 defendants, and there was one attorney who was handling all 19, who was there were 3 other attorneys on the record, but that man, Mr. Eggers, was standing in for all, and he had 9 clients of his own. So it's hard to, and he had himself 3 people seeking asylum, 2 from Colombia, 1 from Cuba. And he didn't mention it during the proceedings.
Because it's not really relevant in the criminal proceeding.
But in
Sal,
Yeah.
sorry,
Can I ask a question? I haven't been around for a while, but in the past, it seemed to me there were 2 pathways to ask for asylum. One, when you got apprehended or come to the border and present, which they won't allow anymore. One from inside the US, not apprehended, to get a lawyer and ask. And that those 2 processes were very different. And especially depending on where in the country you were. So if you were in California, you were in Midwest, you had a much better chance than if you were in New Mexico to get asylum. Is that correct? Or could you explain those 2 different processes? I mean, the people that I knew were not ever apprehended, but they were here without inspection, in New Mexico without inspection.
I think, Sally, you've explained it pretty well. I believe one of them is called affirmative asylum. And I don't remember what maybe the other one is defensive or something, I forget. There's a really good, if you look up the American Immigration Council, they have a number of fact sheets that are very, very helpful, that explain for lay people a lot of many issues having to do with immigration. They have a really good fact sheet about asylum and exactly what you're asking about. And so I don't know how because I'm here in Tucson and I'm not a lawyer, I have tried to learn as much as I can, but our focus has been on here at the border, where so many of the people who get criminalized are border crossers. And so I don't know how much at risk a person would be who wants to present for asylum from the interior of the U.S. But I do know you're right. It depends on where they are, what part of the U.S. they are, which is one of the many unfair things about our asylum system, is that it's not consistent throughout the United States. So I'm not going to be able to shed too much more light on the question that you asked.
I mean, the people that I knew were political refugees from Juarez, and none of them, except one kid whose asylum got denied, ever spent any time in jail.
That's great.
Yeah.
That's what we would wish for everybody.
Any
Are there
more
other
questions?
I just want one more time. What is the organization that you talked about, or the agency? American Immigration
Council, American
Council.
Immigration Council. They do a lot of important work, and they have a good website. You can sign up to get their weekly emails and notifications. A very worthy organization to follow, but they also have these great fact sheets.
Thank you.
Well, could I just introduce Katrina? She has given me some information about her background. She's taught bilingual and early childhood and parent outreach for 20 years in South Tucson. And she's been active in Samaritans down here, and also especially put a lot of effort in Operation Streamline. Since 2 years, she has been really our eyes and ears on what's happening in the court system. It's easy to ignore it because we don't have that big Operation Streamline going, but you know, due process or lack of due process is still happening. So Katrina, did you have anything else you'd like to add?
Thank you. It's good to be here. During once End Streamline Coalition stopped, we had started just sort of monitoring the court calendar. And so that's what I had been doing, is looking at the court calendar for all of Arizona. And Tucson is the busiest federal court. And what we found was there are a lot of the illegal reentry hearings still going on, and not only in Tucson, but in Phoenix. And over the year, it's changed to some degree. About last September, one of the lawyers told me that they were thinking of bringing what they call flip-flop courts. And this is the 1325, 1326. Have a felony and a misdemeanor charge, where the felony is dismissed and the person is convicted on the misdemeanor and sentenced on the misdemeanors. But we still didn't see very much of that until this January. It began to appear in groups. So we would see a group of this particular charge. And since then, they've just slowly been creeping up. And this week with Yuma, that was the first time we'd seen that big a group all together in Yuma. And there's a difference between the individual charges of plea and sentencing that have been around now for a while, and the group charges. Or yes, because the individual ones, when they go through with an individual lawyer, the fastest they can go through is about 4 months. But once they're into the plea and sentencing, it's about a month. The people in Yuma that I saw had all been arrested about a month before, actually on Valentine's Day. And then after their trial this week, all of them would be serving between 30 and 75 days, and then deportation. And once they're deported, that means they have at the least, they have like a 5-year before they can think about returning. And if you get a few of these convictions, you have a permanent ban. Some of the sentencing hearings we've seen in Tucson, just plain sentencing, for 1326, the judge would say, I want to tell you, you must never return to the United States. Must never return. And she would say that with every defendant. So it's a really major thing.
I'll say one more thing to the people that we used to see in Streamline, because it was appalling. It was 70 to 75 people every day, 5 days a week. That's why they had such a massive volume of prosecutions. And that was just in Tucson. And there were other Streamline courts in other border cities. But the lawyers, the people that we used to say in court and say, why are you participating in this machinery of prosecution? And they would say, well, it's a good deal for the migrant because they're not being held in, they're not incarcerated for a long time while this is playing out. It takes a few days. They're only in court for an hour and a half, and they get this plea bargain where they might have gotten, a year in prison. Now they're only going to get 60 days in prison. So it's much better for them. In fact, and so we would shake our heads and think, well, how about not prosecuting them at all? That would be much better for them than what you're describing. But the legal people see it as better for them. And the people, we don't know because we're still tracking this, but it appears that the people that are being selected for this version of Streamline, where we see these plea and sentencing hearings, they seem to be mostly people who do not have past criminal convictions or numerous past illegal reentries on their record. Mostly they're people that have just plain 1326. In other words, an illegal reentry that doesn't have extra stuff tacked onto it. And so so once again, I even heard a lawyer say this a few months ago. I was observing a sentencing hearing for a person who was experiencing a regular prosecution, a 1326 individual regular prosecution. And it was his sentencing hearing. And one of the lawyers remarked, it's too bad, this person is sort of a casualty of the pandemic, because this person would have been a good candidate for Streamline. So it's too bad that he had to go through this regular prosecution. He would have been perfect for Streamline. That's the way they think about this. This individual was somebody who didn't have a whole bunch of extra stuff tacked onto his charges. And he had to sit in Florence for 4 or 5 months while this prosecution played out. If it was Streamline, it would have been a few days, maybe. So that's their attitude about these people. I also want to say that I fully expect, I shouldn't say fully, I give it a very high likelihood that Streamline will be back. Streamline as we knew it will probably be back. Maybe not next month, but I kind of think these plea and sentencing hearings are a precursor. Katrina's also looked at a couple of other courts in other cities or other states to see what we can perceive that might be going on. So if you want to comment on that, Katrina.
Okay, I looked at Bob had asked me a question when I saw him about California and Texas, because Streamline used to have courts all along the frontier, and both of them have a lot of 1326, the reentry hearings going on. They're not, for instance, in California yesterday, they had 9 o'clock, a judge there in San Diego had maybe 10 reentry charges at one time slot, but they were mixed in with transport, which is another very common thing touching on immigration, very common charge. And then in Texas, I looked at Laredo and Brownsville, and they also had quite a few immigration charges, or 1326, the reentry. And you can't tell as much from Texas, shuts up their records a little bit tighter. But if anybody wants to do this kind of research, you just go to the court and pull up the calendars from the day you're looking at. You can
The Arizona District Court, yeah.
Yeah. And the Evo Di Concini, that has all the calendars on it. That has Yuma, and you can access it from there.
I think Susie has a question. Did you have your hand up, Susie?
Yeah, I did. And I am so thankful, Leslie and Katrina, that you are covering this topic today. I continually have questions about it. I don't know why it's so complicated to me. At the moment, I'm focused on a little different thing, since I see the migrants returned under Title 42 in Nogales, Sonora every week. And there is talk of Title 42 being lifted fairly soon. And I think I also read something about they were hoping the process would be slightly different for asylum seekers, and instead of asylum seekers having to go to an immigration judge, it would be an immigration official. And I got the impression they wanted them to be closer to the border. Nogales was chosen very late in the game for MPP because our courts are in Tucson. And I'm kind of curious if you think there's going to be anything different happening if and when Title 42 lifts, and then I presume we will have many, many, many more asylum seekers coming through Nogales. And do you think that the process might be a little bit different, or are they still going to go to a streamline type, a flip-flop type court, because a particular Border Patrol agent is still going to be in charge of deciding, should I listen to credible fear or not? Or will they have maybe an immigration official, which will maybe give them a fairer shake at stating their asylum reasons? It was kind of confusing, but do you understand what I mean?
Yeah, I think I understand. And I'm probably really not qualified to answer, although I think I understand what you're referring to in terms of this planned. In the Biden administration, they have been talking for months about, and maybe even partially implemented, kind of I can't remember the term that was used, but a more compressed, or dare I use the word streamlined, a streamlined method of addressing asylum, people presenting for asylum, and having it done closer to the border and having specially identified. And this has been resisted and fought by immigrant activists, immigration activists and lawyers, because huge concerns about due process. And so, or lack of due process that will likely result. And so, but I don't know where it stands. And so there's MPP, which is still in effect. And, Biden tried to cancel it, but there was pushback and they lost, and now it's still in effect, but they changed the rules a little bit, but MPP is still in effect. Title 42 is still in effect, but for asylum seekers, but not for tourists with visas that can prove vaccination. But I think it will be lifted someday, but they might be waiting until they have their act together for however it is they want to handle asylum seekers. But, you know, it would be great for you all to have somebody from the Florence Project or somebody from Keno Border Initiative, you know, who are there right in the midst of how asylum is playing out in Nogales, talk to you about this very question.
Mhm. Thanks, Leslie.
Well, thank you so much. This has just been so helpful. Unfortunately, not always uplifting, but helpful to learn and hear from both of you. And I really appreciate you coming and sharing your information with us today.